Well, thank you very much, Professor Levine, for joining us today. The Pacific Alumni Associations from everyone, thanks you very much for being here today. And thank you everyone in attendance. We are going to be having a talk today with Professor Levine, and many of you already know who he is. But for those of you who are just coming in, perhaps some incoming students, Professor Levine, he's actually been a frequent panelist, lecturer, and speaker on many legal issues involving torts and sexual orientation. He served on the State Bar Committee on Sexual Orientation Discrimination, as well as the Board of Directors for the AIDS Legal Referral Panel of Northern California and Sacramento lawyers for the equality of gay rights and lesbians. He's been the chairperson of the Law School Admission Council, counsels gay, lesbian, bisexual, and transgender issues on that subcommittee, and a member of the LSAC's Service and Programs Committee. Professor Levine has served on the board of directors of the National Lesbian and Gay Lawyers Association and is a member of the American Law Institute. Professor Levine is a member of the American Law Institute, and he has been a visiting professor of law at UC Hastings College of Law and the UC Davis and New York Law Schools. And I just learned about one of his titles as the Gordon D. Sherman Health Law and Health Policy Chair. So Professor of Law. So thank you so much for joining us today, Professor, and I will let you introduce what you are talking about today, and if anyone has any questions, we will have 15 minutes at the end. You can type in the chat, and we will go ahead and get going. Thank you so much for joining us.
Thanks, Chris. Thanks, everyone. Thank you all for being here. This is my first Zoom chat, lecture, so let's see how it goes. But I now just discovered that I have a huge picture of me in front of me, which is horrifying. It's bad enough that you all have to look at me. But it's really is exciting to be able to talk to you all for a bit about LGBTQ plus rights in the post-Kennedy era. And to get to do that during Pride Month is a particular pleasure. Also, I've been given this gift that I've never been sure when I was able to wear it. So hopefully I could show you all that I have this Ruth Bader Ginsburg Gay Pride t-shirt. And so this seemed like the right occasion to unveil that. So thank you for giving me that opportunity. It turns out that every one of the Supreme Court decisions affecting the LGBTQ plus community has been issued in the month of June, including the decision providing equal access to the institution of marriage. And this June has been no exception. As many of you no doubt know, the post-Kennedy court issued its first LGBTQ plus opinion just a little over a week ago, which was a resounding victory for the gay community. And it was a 6-3, not a 5-4, as usually has been the case, but a 6-3 opinion in which the court decided that Title VII's prohibition against employment discrimination based on sex encompasses discrimination based on sexual orientation and gender identity. I'm going to, excuse me, I'm going to talk about that opinion for a bit because I know it's on many of your minds, and it's certainly on mine. I keep pinching myself because I'm as surprised as I am delighted by the outcome of that opinion. It's really quite a monumental victory for LGBTQ plus legal rights. Luckily I have this water. I want to note that while there's much to celebrate regarding this opinion that it's called Bostock, we find ourselves at a time of enormous social upheaval with increased recognition of the systemic racism throughout our society in many of our institutions, particularly in the criminal so-called justice area, among others. And in a conversation about employment discrimination, it seems appropriate to think about the impact of discrimination on race and ethnicity, along with the topic that we'll be focusing on today, sexual orientation and gender identity. I also want to remind folks about the role of intersectionality when we think of trans women of color, for example. There is no demographic that is more affected by employment discrimination than that. And so I hope we can be mindful. And also, before I get to the substance, I want to acknowledge that many people who are listening in today are alums of McGeorge School of Law. So therefore, I have with us some of the greatest legal minds in the country, or at least people who think they're among the greatest legal minds of the country. But also joining us are alums of other schools at the University of Pacific and friends of the university who don't have a legal training. So I'm going to aim to paint with a rather broad brush. And for those of you who want to delve in more deeply, please feel free to, if I don't get to your thoughts and you have ongoing questions, feel free to email me at llevine@pacific.edu. And I also expect that for the legal community that we'll have in the fall an opportunity to have a similar program where we dive more deeply into the Title VII, the Bostock opinion. And I hope that in that discussion, my incredibly talented colleague, Brian Slocum, will be able to join us, because Professor Slocum indeed was a co-author on one of the amicus briefs on the prevailing side of this very case. And hearing from him would advance the conversation mightily. I want to start out by sort of a confession of sorts, which is my original plan was to talk to you all about the precarious nature of LGBTQ legal rights after Justice Kennedy's departure from the Supreme Court. And indeed, this is the nature of my current sabbatical project. So this opinion has thrown me a bit for a loop. It's not what I anticipated. The good news and the bad news is I still think there's plenty of room for concern. And so my general pessimistic nature as a big gay thundercloud of doom still has a place. But for the moment, there is something substantial to celebrate. Indeed, I was only planning on touching on this Title VII case briefly because, like many people I know, I expected the Supreme Court to come out the opposite way. I expected the position taken by the dissent to actually prevail, which was the argument that to find that sexual orientation or gender identity was encompassed in Title VII would require an act of Congress, an amendment to Title VII, and that the court would be overstepping its bounds in doing so through a judicial opinion. And so I shouldn't be completely surprised based on the oral argument, and also as a fact, the overwhelming majority of Americans, including the overwhelming majority of Republicans, have long taken the position that people should not be terminated from employment based on sexual orientation or gender identity. But I still didn't expect the court to come to this conclusion, so I'm scrambling a bit and revised my talk considerably. And I also want to, while I'm confessing, I can't see you all, but it's cathartic for me to perhaps to confess this. I'll even admit that I'm personally a bit conflicted about the opinion. And I expect to get some pushback from some of you on that. And I welcome and I really invite that pushback. A part of me thinks that it would have been better to have had Congress indeed amend Title VII or to pass the Employment Non-Discrimination Act or the Equality Act, which is currently wending its way through Congress. Now, with that said, I don't want to understate the monumental impact of what the Supreme Court did in the Goresuch opinion. Before this decision was decided just a week or so ago, in a majority of states in the United States, a person could be refused to be hired or fired from the person's job simply by virtue of being LGBTQ. And with the stroke of a pen, now that with this decision in all 50 states, there is protection for sexual orientation and gender identity. So in no way do I want to minimize the impact of this opinion. But I will say that when I teach my sexual orientation gender identity class, the first class is dedicated to a discussion about the differences among sex, gender identity, gender expression, sexual orientation. And now I think it's worth considering whether the sexual orientation gender identity class should simply be subsumed into a gender and law class. And for some period of time, I made that argument, and now there might be added vitality to that. It's important to underscore that the Goresuch case is a case about statutory interpretation. It is not about a constitutional interpretation. The prior cases involving LGBTQ plus rights have been constitutional. And we'll talk later about the degree to which this case affects those constitutional cases. And in fact, that was going to be the main part of my talk, was about the fragility of those constitutional decisions. And I'll be able to touch on that. Maybe we'll get to some of that in the Q&A. But this is a statutory interpretation case. It's an important distinction. Title VII was passed by Congress in 1964, and the Supreme Court in Goresuch is interpreting part of the language of that statute. The Supreme Court is interpreting the because of sex language in that statute. Title VII prohibits discrimination in employment based on a variety of categories: race, religion, and because of sex. And that is the focus before the court. And that was really their only task. And Justice Goresuch, for the majority, takes on that task, and in a rather, he would argue, straightforward, and some said a mechanical manner, looked at and interpreted the language of Title VII. In fact, no good deed goes unpunished. And I have read criticism of Justice Gorsuch's majority opinion for being soulless, for not really talking in the prior terms that the Supreme Court has used, mostly Justice Kennedy, talking about the dignity of gays and lesbians, and instead having a rather mechanical interpretation of language. But let me just say, his approach certainly gets the work done and brings about a result that appears to be as simple as it is revolutionary. To him, to Justice Goresuch, the case is only about the meaning of the written words "because of sex" as used in Title VII. The plain or ordinary meaning of these words is the only appropriate focus, according to him. The intent of Congress in 1964, or what people might popularly believe is meant by the use of sex in the statute, is not relevant to the interpretation. And therefore, he writes a very clear opinion, I think a beautifully written opinion, that will be used in statutory interpretation courses for sure. McGeorge now has a first-year course on statutes and regulations, and I assure you that this is going to be a major focus of that course. Justice Gorsuch notes that the task before the court is quite a simple one. He says, we must decide whether an employee, let me try that again. We must decide whether an employer can fire someone simply for being homosexual or transgender. The answer is clear. An employer who fires that person for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. Sex plays a necessary and undistinguishable role in the decision, exactly what Title VII forbids. It's very straightforward and persuasive. He concedes that in 1964 that Congress only intended biological sex was meant by the use of the term sex. He acknowledges it wasn't meant to reach sexual orientation or gender identity. And therefore, the part of Justice Alito's dissent, and Justice Alito's dissent is longer than the majority opinion. Justice Alito spends a long time talking about how there was institutionalized anti-gay animus in 1964. And frankly, that transgender rights were not even really on the radar in any significant way. But to Justice Goresuch and the majority, none of that is relevant. To Justice Goresuch and the majority's holding that sexual orientation discrimination and gender identity discrimination are subsets of discrimination based on sex. And those forms of discrimination were always prohibited by the clear language of Title VII, what he calls the ordinary public meaning of the statute's language. As an example, Justice Goresuch lays out an example of two employees, both of whom are attracted to men. They're identical in every way, except one is male and the other is female. If the employer fires the employee who is male because of his attraction to men, that necessarily is discrimination based on sex. Yes, it's also discrimination based on sexual orientation, But according to Justice Goresuch, the discrimination based on sexual orientation is a subset of the discrimination based on sex. That it's necessarily discrimination based on sex. If the employee had been female, the result would have been different. Now, this may seem to you all so incredibly obvious. And when you read the opinion, it seems to me like a no-brainer. But I do want to acknowledge that it wasn't until 2017 that any federal appellate court came to that determination. And so to some, this is a rather novel and surprising result. Now, it's true that the Supreme Court has given an evolving interpretation to the language of Title VII. They've gone beyond what the drafters intended in earlier cases. For example, they concluded that Title VII sexual harassment reaches Title VII sex discrimination includes sexual harassment, including same-sex sexual harassment, and also gender nonconformity more recently. But it is a substantial step for the court to then do what it just did, which is to say all sexual orientation and gender identity discrimination is necessarily a subset of sex discrimination. Justice Alito writes a long and angry dissent. Someone described his dissent, which was joined by Justice Thomas, as an angry dissent, where Justice Kavanaugh, the other dissenter, writes an apologetic dissent, saying, gee, sorry, I really wish I could rule in favor of the LGBTQ community, but I just can't based on my statutory interpretation. But Alito's dissent is a long and an angry one, and I think a lot of it is really unrelated to the issue really that we're dealing with in terms of statutory construction. But he did raise at oral argument, and again in his opinion, an interesting hypothetical that I want to at least lay out for you to think about, to grapple with a little bit, if you will. And again, I wish, this is what kills me, I can't call on you all. And there are people in there, some of my ex-students, and you know how much right now I wish I could call on you. But let me go on. So in this hypothetical that Justice Alito posits, there's a phone interview of a job applicant who we'll call Pat. Based on Pat's resume and based on Pat's voice, it's impossible to discern Pat's biological sex. Based on the interview, the employer says, this sounds great, I think you're a perfect fit for the job, we'd really like to hire you. And Pat says, great, I just have one more thing that I should mention. It's not a problem to you all, is it, that I'm in a same-sex marriage? At which point the employer says, no, we're not gonna hire you. Justice Alito says, well, that's sexual orientation discrimination. It can't be sex discrimination because the employer didn't even know the sex of the job applicant. And at oral argument, the lawyer for the plaintiffs even conceded that point, probably wrongly, absolutely, clearly wrongly in light of how the majority opinion comes out. Justice Goresuch would say it's necessarily sex discrimination because sexual orientation discrimination is a subset. But at least I think it's something to think about. I think the gender identity piece is a much stronger argument that falls within the concept of sex, Title VII. Sexual orientation is a bigger step, I would say. Now, what's the reach of the Bostock, the Title VII opinion? Well, here I want to thank Justice Alito. he pulled a Scalia. And by that, what I mean is, in some of the earlier opinions, in his angry screeds, Justice Scalia would write about all the horrible consequences that will flow from the majority opinion. In fact, Justice Scalia went so far as in the Windsor opinion, where Justice Kennedy said that the Federal Defense of Marriage Act was unconstitutional because it did not provide federal marital benefits to same-sex, legally married same-sex couples in those states that permitted same-sex couples to marry, but restricted them only to other sex couples. And Justice Kennedy said that was unconstitutional. But he also said this case has nothing to do with whether there's a nationwide constitutional right to marry. This is only about those states that confer the right to marry. Well, Justice Scalia rewrote in his dissent the majority opinion and said, see, this is going to lead to nationwide same-sex marriage being constitutionally required. And Scalia was right, because in Obergefell, that's exactly what Justice Kennedy did. Well, here Justice Alito lays out over 100 federal statutes that use the language because of sex, and says all of these statutes now are going to necessarily have to include sexual orientation and gender identity. I really hope he's right. And I think he's right, because I don't think there's a meaningful distinction. Of course, Congress has the power to rewrite these statutes, to narrow them. But as things stand now, so for example, Title IX involving sex discrimination at schools, including universities, including athletics. I think that Justice Alito is quite right, that discrimination there because of sex, despite what Betsy DeVos and the Trump administration tried to argue, at this moment, because of the Bostock opinion, that encompasses discrimination based on sexual orientation and gender identity. To me, and what I'm working on, and what I'm gonna not have much time to talk about, is the degree to which the Bostock opinion applies to constitutional LGBTQ rights. All the prior decisions, as I mentioned, were constitutional opinions based on the Due Process Clause or the Equal Protection Clause of the Constitution. There are cases pending right now. One of the most glaring would be the Trump ban on transgender soldiers serving in the military. That is working its way through the courts. Up to this point, and one of my main criticisms of Justice Kennedy's jurisprudence is that Justice Kennedy could have, but did not, explicitly provide what we would call heightened scrutiny to gays and lesbians and transgender individuals. But now, because of Bostock, is it it's certainly an argument, will it be a winning argument, that discrimination under the Constitution involving gays, lesbians, or transgender individuals is sex discrimination? Because if it's sex discrimination, it's automatically entitled to heightened scrutiny. It's much harder for the government to limit the rights given that higher level of scrutiny. I don't know the answer to this. This is going to be a huge area of debate. What Justice Alito says in his dissent, and he says so with expressing great worry, is that this Title VII opinion may exert a gravitational pull in that direction. Well, I really hope that there is, in fact, that gravitational pull, because that will have profoundly important consequences. Before I open this up for discussion and your questions, I would be remiss if I didn't touch upon what I think are some of the largest remaining legal issues involving LGBTQ plus legal rights. Issues that the Supreme Court has already agreed to grapple with in its next term, and there are still some opinions this term that will affect this as well, which is the tension between non-discrimination laws and religious liberty. In Bostock, Justice Goresuch signals support for broad exceptions for religious institutions to refuse to hire or fire individuals based on the asserted religious beliefs of that institution. And there's many of these cases where employers are asserting that their religious tenets include anti-gay or anti-trans perspectives. Now, many religions, of course, have religious tenets that embrace the rights of the LGBT community, LGBTQ equality. But can a religious school fire a teacher when they learn that she's in a same-sex marriage? Can a religious school fire a janitor when they discover that that janitor in her off time is playing on a gay softball league? The size of this exception, there clearly are going to be exceptions, and how big those exceptions are will decide how much it undercuts the reach of this Bostock opinion and many other contexts that are affected by this because of sex language. Indeed, I want to take a moment before we get to your questions to underscore the extent to which there is anti-gay LGBT animus in employment. Sometimes I worry that by being in California, we naively think that this just isn't a problem. Well, just look at the plaintiffs in the Bostock case. Bostock really is the consolidation of 3 cases. And one involves Amy Stevens, who was a funeral director in Michigan, who transitioned, and because she transitioned and was transgender, she was discharged from her employment. Another involves, in Georgia, a man who worked for a county child services organization, and it was discovered that he was playing on a gay softball league. He was fired because it was discovered that he was gay. There was no debate, no denial that was what's going on. Of course, in these cases, there's going to be huge proof issues. Like in the 3rd case, the employer does deny that they fired the gay skydiving instructor because he was gay. So there's a factual dispute. But let's be clear, there is ample evidence that people are not being hired or being fired because they're LGBTQ+. I expect that the big legal battle is going to be over this tension between anti-discrimination laws that protect LGBTQ folks and these claims of religious exemptions. Next term, the Supreme Court has already agreed to decide if the city of Philadelphia can constitutionally exclude a religious adoption agency from its foster care system because the adoption agency, the religious adoption agency, refuses to place children with legally married same-sex couples, though they do so for other sex legally married couples. This litigation is going to be ongoing because Justice Kennedy's parting shot, his last decision before he left the court, was Masterpiece Cake Shop. And in Masterpiece Cake Shop, Justice Kennedy was troubled by this tension that I'm describing. And he decided that because Colorado government officials evidenced what he viewed to be anti-religious animus in how they dealt with the Christian baker involved in that case, that the Colorado was wrong to force that Christian baker to make a wedding cake for a same-sex couple when the baker claimed that to be in violation of his religious perspective. Now, Justice Kennedy suggested, but sadly did not hold, that in conferring goods and services, it is not okay to discriminate on the basis on a religious claim in the provision of goods and services where there's a non-discrimination policy protecting the LGBTQ plus policy. He suggests it, but again, it's a missed opportunity. And so we now have a lot of debate about the parameters of the tension between these two interests. Just last August, the Eighth Circuit Court of Appeals, by a 2-to-1 vote, determined that Minnesota could not force a videographer to provide its services to a same-sex marriage in contravention of that state's non-discrimination policy. Conversely, the state of Washington determined that a florist could not refuse to provide flowers for a same-sex marriage, even though she claimed it violated her religious perspective. Therefore, we're going to have a lot of ongoing litigation about this issue. It's sort of a full employment act for lawyers. And I wonder, and I'm interested in your thoughts, either today or by email, of whether there's room for compromise here. Is there a distinction between providing goods and services, such as providing baked goods, as opposed to providing custom goods requiring the special skills, the artistic skills, such as a custom-made wedding cake, or selling wedding invitations, as opposed to refusing to provide hand calligraphy for wedding invitations that will be used for a same-sex couple. To me, I really struggle with this because discrimination to me is discrimination. But we do have to carve out some room for the religious exemptions. How we get that balance is a difficult one, and I'm really not sure where it will come out. I'll end, before we go to questions, that's saying that I guess the good and the bad news of this decision and the subsequent issues that it raises is that there's plenty of litigation ahead regarding the extent and the nature of LGBTQ legal rights. So I'm going to be able to stay employed writing and lecturing on these issues, but it sure would be nice to get to the point where no longer will there be a need for me to teach a course on sexual orientation, gender identity law, that we get to a place of true equality, but we're not there yet for sure. So thank you, and with that, let's open it up for some questions.
All right, thank you so much. So yeah, we have some people typing in questions. Also, if you don't have questions per se, but if you want to make any comments with your take about goods and services and those, please put those in the comments, and we'll see those coming through. So we give a moment for people to be able to type in any questions.
My shirt was a gift.
Yeah,
for the,
I was gonna say, let's start with an easy one.
Someone wanted to know where I got this fabulous shirt. It was a gift that I've been very grateful for, but I don't know where it came from.
All right. How about one from John Gutierrez here? Earlier you mentioned that today discrimination towards the LGBTQ plus persons is sex discrimination based on the ordinary public meaning. Can you expand on what the concept of ordinary public meaning is and why it might matter to the court?
Sure. So thank you for that question. And I had the pleasure of meeting you yesterday, I believe. So I'm delighted that you're here. So to Justice Goresuch, it means everything. In fact, it's kind of interesting that in the Bostic opinion, both the majority, Justice Goresuch, who brought the Chief Justice along with him, so that it was a 6-3 opinion, both the majority and the dissenters claim fealty to the approach taken by Justice Scalia. So it does suggest that there's different interpretations of statutory interpretation that even if you're trying to be somewhat literal. So the idea is that Justice Goresuch looks at the language in Title VII that says you cannot discriminate in employment because of sex, and says if the result would be different, that the person wouldn't be terminated or would have been hired as opposed to we would refuse to hire them had they been a different sex. Then this constitutes, on the plain language of because of sex, this constitutes sex discrimination. So again, that if you would hire a woman who dates men, but you wouldn't hire a man who dates men, that necessarily is sex discrimination under the plain language of Title VII.
All right. Thank you. So we have a question from Alan LaFaso. Can you comment on Justice Goresuch's analysis to get to the sex discrimination and SO/GI discrimination?
Sexual orientation, gender identity. Yeah, I mean, Alan, thank you for that, and thank you for being here. So Alan and others, it's similar to what I was just saying. What I think is so extraordinary about Justice Goresuch's opinion is it's so clear. You read it Because, I mean, just among us, even though this is being recorded, but no one will ever listen to the recording, this is an extraordinary result. Like I said at the outset, I would have bet anything, like I didn't bet, but I absolutely would have bet enormous amounts of money that the Supreme Court would not come out the way they did. Because this is a substantial change. This argument has been made since the 1970s without success. In fact, the California Supreme Court, when it found that the California Constitution confers a right on gays and lesbians to access the institution of marriage, they said, under the California Constitution, to justify sexual orientation discrimination, the government has to make a showing that there's a compelling state interest. Under the California Constitution, they can't do that. But then that same Supreme Court of California said, oh, but we don't find this to be sex discrimination. This argument that because a man can marry a woman and a woman can marry a man, but a man can't marry a man, a woman can't marry a woman, we're not going to find that to be sex discrimination. Well, here you go. And so it's true that it's taken us till 2020. And this argument's been made for decades to get where the majority did. But if you read Justice Gorsuch's opinion, he makes it seem like an absolute no-brainer that when you look at the language of Title VII and consider only the plain meaning of that language, you must conclude that sexual orientation and gender identity discrimination is a form of sex discrimination.
All right, and then just kind of a second part to that question, other than the obvious reference to RFRA as a super statute, is there anything else in the analysis to worry about from your opinion?
That's kind of, I mean, and I mean this with all the love I can muster, it's a little bit like, other than that, Mrs. Lincoln, that is exactly language that I seize on. That plus the opinions of Justice Gorsuch and Justice Kavanaugh, and the clear indication of Justices Alito and Thomas, that suggests that they're going to give a very broad interpretation to religious liberty exceptions. And so how big a hole that will make in this opinion is yet to be determined. But by looking at RFRA, the Religious Freedom Restoration Act, giving broad interpretations to religious liberty can create significant exceptions to anti-discrimination laws, Title VII being one of them, but these other 100 statutes. We'll see what states do. I failed to mention that already the Bostock opinion has had an impact on some of the state courts in the last week. So some of the state courts are now revisiting the meaning of sex under their own statutes based on Bostock. So the court, this opinion could be very far-reaching, or it could be reined in considerably depending on the nature and scope of those religious exceptions.
Right. So towards the end of your talk, you had mentioned humanity. So Stephen Coppola has a comment, question. Perhaps maybe instead of carving out space for religion, maybe carving out space for humanity. Think of the cake maker who holds their religious beliefs in good faith. Think of the feelings they will have of anger as they make the cake. Why should my rights as a gay man who was fired for being gay 1 month after being told I would be partner be more important than the right to the happiness of another?
I think that's exact. Thank you, Susan, and for that question. That's exactly the tension that we're going to that the court's going to have to grapple with. But under your argument, my question would be: where do you draw the line? Can a bed and breakfast, for example, say, "Oh, do you want the honeymoon suite? Well, we reserve that for other sex married couples, but we won't allow same-sex married couples to have access to the wedding suite at our B&B." I mean, my reaction to that would be, if you choose to run a hotel, provide services and goods, you are agreeing to provide them in a non-discriminatory fashion. I think, to me, I mean, just as you may think it's clear on the other side, I think it's pretty clear that that's incumbent upon you in the provision of services, that you don't discriminate. Now, where I think the harder issue is, so for example, a stationery store finds out that a customer is going to buy a packet of pre-printed invitations, wedding invitations, to use for a same-sex wedding. I kind of think you would agree with me that store can't say, no, you can't buy that pre-printed packet of invitations because we don't serve gay people who are going to be getting married. It's harder if they're hand calligraphy and you're saying, we want you to handwrite these invitations. Here, I do think this is what I'm kind of looking for, where there might be some common ground. Even there, I'm not sure. I mean, there's an argument that if you've chosen to provide those services, you should do so on a non-discriminatory basis. But there does have to, the easiest thing would be, yes, a synagogue does not have to hire a Christian to be a rabbi, right? I mean, there's clear situations where religion is going to matter. Maybe in terms of religious schools, that they may say, if you need to adhere to the tenets of this religion to teach at this school. When you get to the janitor, does it really matter that the janitor plays for a gay softball league? So this is, to me, where the tension lies.
Yeah, and that Liz Travis looks like she was going down that road as well of kind of pondering the limits of the religious principles and how far that could be taken, and what other discrimination might be supported by the religious exclusion basis. So I think many people are kind of pondering that along with you.
Well, I will say, and this. I feel like a kind of a bad person. Well, many of you are my former students, so you already know I am. But last summer, there was a lawsuit brought against a wedding venue in the state of Mississippi because the owner of that wedding venue refused to allow it to be used for interracial wedding. And the owner said, this violates my religion. That my religious view is that God only favors unions of people of the same race. Therefore, you cannot force me to allow an interracial couple to have access to my wedding venue. I mean, I felt bad that I was somewhat gleeful because I said, see, here we go, right? Here we go. And so if we start carving out the exceptions based on sexual orientation, gender identity, will it lead to other exceptions like this one? Because when it came to race and interracial marriage in the 1960s, this was exactly the argument that religion was, what a person's religious view prohibited them from supporting interracial marriage.
Right. So we are getting just past 1 o'clock. And so to be mindful of everyone's time, I do want to say thank you very much for everyone who has joined us today. If you have any further questions, as Professor Larry Levine did mention in the beginning, please feel free to reach out. You can reach out to him directly. He did say that. And
L. Levine at pacific.edu.
L. Levine at pacific.edu, as well as either of your alumni associations. We are happy to, if you have more comments, any other, if you want to have more in-depth conversations about this, have your voice be heard, talk to your alumni associations, and we'll get in there. So definitely on here. Thank you very much. Lots of people, lots and lots of love right here. So thank you so much for being here. It's awesome. Yeah. So
all these great people. Thank you so much for being here. And I wish I could be physically with you all, but this will do for now. So stay safe, and thank you all for being here.
Thank you. Thank you.
Thank you.
All right. Excellent.